Welcome to the Black Table, an hour devoted to exploring ideas and subjects of special importance to African people and others fighting to build a better society. I'm your regular host, Greg Carr, and we're joined again today with our legal roundtable, Angela Porter of American University and Valethia Watkins of Howard University. As you know, here at the Black Table, we have devoted all of our energy to building a conversation that allows us to have a firmer grasp of contemporary issues, connect them historically, and to kind of, just build that muscle so that when we take collective action, we can do so with the best information and the best thinking across a range of opinion. When we convened last week, we continued discussing actually, the recent Supreme Court of the United States, their recent docket, their 2021-22 docket. And when we left off last week, we actually previewed the conversation for today. We're going to talk about the Supreme Court decisions, not only of the last term, but the coming term in the fall of 2022. We know the move to the right, the Supreme Court has, as the three liberal justices have said in their dissent in Dobbs versus Jackson, we've seen a court that substitutes a rule by judges for the rule of law, and not thoughtfully, not slowly, particularly since the addition of Amy Coney Barrett. The court has struck down a number of precedents, overturned precedents, said there's no right to privacy in the Constitution, strengthened people's ability to carry firearms openly in the streets of New York and probably much of the rest of the country, curtailed the Biden administration and all administrations theoretically ability to use the administrative structure and apparatus, to curb and contain climate change and COVID. So what's next? Let's convene our legal roundtable, our regular legal roundtable. Professor Porter, Professor Watkins, welcome back.
Thank you. Good to join you today.
Yes. Thank you. And, for our viewers who have been watching over the arc of our roundtable here, we know that Professor Angela Porter was a fellow at Georgetown. She came back to DC, double graduate of Howard University, to take up residency at Georgetown University for a 2-year fellowship. But then there was an intervention. In fact, the faculty at American University School of Law, led by Roger Fairfax, who of course is a good friend of Ketanji Brown Jackson, the most recent justice of the Supreme Court of the United States, looked out over the landscape and saw this brilliant young legal star and said, let's recruit her. So in fact, Professor Porter, could you help our viewing audience who's gotten familiar with you now over the arc of the Black Table and other places you appear, say a little bit, if you don't mind, initially, before we get into the conversation about where you'll be taking a residency in the fall.
Oh, yes. I'll be at American University, Washington College of Law. So excited to be there with those students. I'll be teaching torts and Africana legal studies.
Oh, wait a minute. Africana legal studies? That's not taught at law schools. What are you talking about? That critical race theory, is that CRT, Professor Porter? What is Africana legal studies?
It's not CRT. It's another legal theory that is an extension of Africana studies. So the subject I learned from people like you and Dr. Watkins and Dr. Mario Beatty and others, where we're looking at what African people did for themselves in the way of governance or protocol, as I like to call it.
Yes. Well, thank you. Thank you for making that comment. We got a chance to see a preview of that with your students at Georgetown that you taught in the previous term, and just to see how they responded to this field. And everyone, this is a field that Professor Porter is not only pioneering, she's literally creating this space. So we're going to watch this space and see it grow.
No, it's a collective effort.
It's collective effort for sure. But somebody had to name it. Somebody had to name it and frame it. Professor Watkins, could you help us with your colleague? Because she just doesn't want to take
it. She's leading the way. This is exciting and very innovative work. So we're all going to benefit from it.
Absolutely.
Thank you.
And actually, I was in Houston recently for the 43rd conference of the National Black United Front. And I have a message for you, Professor Watkins. I want to do that right here as we get into this topic. The folks in Texas told me to tell you that they want to hear more from Valethia Watkins. So, one of these days, we're going to devote a whole a whole session to your theory of Africana women's studies, because you are leading the way in that and have been for quite some time. So I just want to put that marker down at the black table. Stay tuned, you all. Stay tuned.
Shout out to our family in Texas. We look forward to the conversation. And also, we're just applying the Africana Studies framework that Dr. Carr has pioneered to all of these different areas of study. And it is producing a new conversation, linking us to our long view of history and culture. So we're just excited to be in conversation as a collective.
Very good. Well, appreciate you, sis. And we are working as a collective. So now that we've exhausted the Mutual Admiration Society, let's get into the world that we're living in, hacking and packing our way. What the hell is going on with the Supreme Court? Professor Porter, just before we went live, you had a metaphor. You mind sharing that with the audience here at the table?
Well, I think it's a common metaphor that I hear most recently from my own sister. She said, the Republicans are playing chess and everybody else is playing checkers. And when you study the case law of the Supreme Court, that really rings true, because what the conservatives are doing is small moves, this incremental plan that is a very long-range plan that spans decades. So any one case might seem innocuous. It might not seem like it's tearing down the whole system of guaranteeing rights to our people and others who are oppressed in this society. But when you look at all of the moves together, they're lining it up for a checkmate. And we are very close to checkmate today. I think when we preview the next term of the Supreme Court, you're going to see that we are very close to their long-range goal of retaining power in this country.
My God. Well, as we were talking before we went live, we spent these news cycle after cycle, talking about many of these cases. We talked last week about them here at the Black Star Network, but often we don't see them connected to each other. So what we wanted today to do, and of course, we've talked last week about Dyer versus Jackson, New York State rifle versus pistol with the right to open carry, the main case where tax dollars now are able to be spent on religious schools, the school prayer decision, West Virginia versus EPA, as we mentioned, and several of the other ones. The common element, though, is this struggle over, originalism versus a living constitution. Either of you mind helping the audience understand so when we hear these justices, these so-called conservative justices, say that they are adhering to a theory of originalism, what are they talking about? And how are they using that as a kind of battering ram to pursue this agenda?
Well, Angie, I'll defer to you to share that.
Thank you, Dr. Watkins. Well, originalism is this idea that we look back at the Constitution and we derive the meaning of the Constitution by what it would have meant to the folks who drafted it back in the 17 and 1800s, depending on which section we're looking at. So this idea, though, is not an originalist idea. It came about after the constitutional revolution of the 1960s, often referred to as the Warren Court. Earl Warren, Chief Justice Earl Warren, best known in our community for the Brown v. Board decision. He became Chief Justice right when that was being decided. In fact, at first, Brown v. Board was not going to be a unanimous decision. The Chief Justice died, and then Earl Warren comes in. They think he's going to be a conservative justice, and he ends up not being that. And he rallies the court and says, we're going to do a unanimous opinion on this.
Yeah, I should add, Professor Porter, just to inject very quickly as you continue, that a lot of folk may not know that Warren was an elected official before he joined the Supreme Court. He was the governor of California.
He was in California, and he was there during Japanese internment camps. So, by all signals, he was a conservative, but he comes in the court and he leads this constitutional revolution, which is, I think, in popular imagination, the Supreme Court is that court. Yes. Well, since that time, just as the right does whenever they are swung out of power, they have been plotting and planning on ways to dismantle the power. And one of those ways has been this theory of originalism, which really came to a head in the 70s and 80s, and now is sort of the theory of the day. It is what the justices use in their deliberations.
Interestingly enough, I mean, for folks who think that the court isn't political, clearly it's political. There have been, I think Senator Dale O'Connor was the last elected politician to serve on the court in its kind of recent iteration. But this question of originalism, Dr. Watkins, it seems fairly flexible. I mean, it seems patently absurd for Clarence Thomas to talk about originalism, since he'd be somewhere chopping cotton or in tobacco with his shirt off if we were talking about originalism. But I mean, what is this hang up they have with these Civil War amendments? You've taught and written extensively about these 13th, 14th, and 15th Amendments. Why is that important in this conversation? And maybe we'll continue this in the next block, but at least introduce it for us here.
Well, you know, these in many ways gives a new birth to a new constitution. 13th Amendment basically outlaws slavery, except, and the biggest exceptions in the case of criminal conviction, or the case of being labeled a criminal, then you could be forced to work without compensation. And the 14th Amendment being one of the most important: due process, birthright citizenship, and equal protection clause. And this amendment that really opens the door for treating African people as equal citizens, in many regards, has been reduced to protecting the rights of corporation. And then the 15th Amendment allowing African people to participate in the political process, not just to vote, but to run for office. But yet there were political constraints, anti-democratic or anti-democracy movements after the Civil War that we're facing today. So Professor Porter is absolutely right. We cannot look at these cases in isolation, because at the heart of democracy is the consent of the governed and the ability to participate in political decision-making through representative government. And so there is any accident why they struck at the Voting Rights Act, and they're going beyond stopping you from voting. We're on a fast track to fascism. We are facing an anti-democracy movement, and the court is acting as the judiciary arm of the GOP. So they're not just acting political, they're acting as partisans, and that they are a very hostile court in that regard.
Thank you. We're going to take a pause here and come back. Thank you, Dr. Watkins. Before we come back, you wanted to say a quick word about originalism, Professor Porter, before we come back?
Just a quick word, and Dr. Watkins and I talk about this all the time in our work, but there is no one way to tell history. So as soon as you dabble in history as part of your legal theory, it's not neutral. They pass it off as neutral, but the way you characterize history depends on your orientation. So what we have is a very skewed view of the history and an orientation that is very conservative and favors white people above all others. And so that's the issue with originalism in any context.
Thank you. Reminds me, of course, we talked about Justice Breyer in that dissent in Bruin when he accuses Amy Coney Barrett of cherry picking through the history to tell the story she wants to tell. Very, very good point. When we come back in a moment, we're going to look at the majority's thought process, this Supreme Court, particularly Clarence Thomas. Has he signaled what else is at risk? I think we all know he has, but we're going to come back to this when we come back, and we're going to tease out some of the logic behind the decisions that we had in this previous term, and look forward to the next term here at the Black Table. Back in a moment.
put 10 in here?
10, and you don't come out until you die.
And you eat him, you eat 10.
Oh my God.
So what?
Welcome back to the Black Table here on the Black Star Network. I'm your host, Greg Carr, joined with our regular participants in our legal roundtable, Professors Angela Porter and Valeethia Watkins. Colleagues, our friend Clarence Thomas, calling out contraceptives, calling out same-sex marriage, Griswold, Obergefell, Lawrence versus Texas, and Texas sodomy laws. What is at stake in what are the patterns that you all saw in the previous term, and how is it setting up this project you all introduced in the first block as we talked about this agenda that is being pursued?
Well, it's certainly attacking the right to privacy. And basically, it's really a contradiction because they're saying the word abortion, for example, doesn't appear in the Constitution. So therefore, you don't have a right to that. But the word slavery didn't appear in the Constitution, and yet they used the Constitution to protect the economic interests of slavery. Judicial review doesn't appear in the Constitution. Marbury versus Madison, one of the first cases that the court said it is the last word on the constitutionality of the Constitution. Thirdly, they basically have given corporations rights under the 14th Amendment. That doesn't appear literally in the Constitution. So again, cherry picking history and using this fancy term, and they have many other theories that sound so fancy, but are really made up code words for interpreting outcomes the way they want the outcomes to be based on partisan interests.
That's interesting you say that, because I was thinking about there was a series of lectures at Harvard. I think it was Sean Willentz. I've had a book over. It's called No Property in Man was the title he gave to it, where he makes the argument that the Constitution was not a pro-slavery document, even though we had the 3/5 compromise. And you said, even though we have the ban on the import of human beings after 1808 in the Constitution, and several other references that are clearly to slavery, but Willentz's argument is, yeah, but they recognize that these are human beings, and they really set up a framework so that when it came time to abolish enslavement, it could be done through the Constitution. But you're raising something, Prof, and I hope one or both of you will jump in and comment on this. This question of judicial review, this question of judicial supremacy, and I know we're going to come back to that in our final block when we start talking about solutions. And I mean, it's strong throughout the conversation we're having, of course, but whether it be expanding the court or looking to other ways of political participation, are we really giving too much power to the courts? I mean, people are saying, well, yeah, they made these decisions, but can they enforce them? We see the states, California, New York, passing legislation, setting up a battle over terminating a pregnancy. I wonder, could you help us think about what's going through the minds of these justices who have engaged in this, as you say, Professor Porter, 50-year kind of march to roll back this kind of progress that most of us want? Are they counting too much on what they assume is their power? They don't have an army. They don't have a navy. They don't have a way of enforcing beyond us just respecting the quote unquote rule of law.
Well, their power is waning because, as you noted, the majority of people feel otherwise. They disagree with the court's decisions, and you need buy-in to make the court a legitimate body. And so by being so hyper-partisan, they are losing their legitimacy. And I think what the other side needs to do, what folks who consider themselves to be liberal need to do, is act like the Republicans have been acting. They have essentially launched a legal movement where they challenge laws that are currently considered constitutional, or they pass laws in the state legislatures that they know go against Supreme Court precedent. So they can tee up cases, test cases that go up to the court. So they sort of just act with impunity. They don't really care what the court says. They say, we're going to shape this court.
Let's talk about that in the terms of a case that, as you were mentioning before we went live, kind of flew under the radar. I know Roland talked about it on Roland Martin Unfiltered very quickly, and Cliff and Latosha, Cliff Alford, Latosha Brown, Black Voters Matter talked about it. But this Alabama case, this Miro versus Milligan case, attacking the Voting Rights Act and using this thing they call a rocket docket or the shadow docket. Could you talk to us a little bit about that? And then how, in acting with impunity, they simply are trying to deprive people of their ability to be represented in their voting and the full expanse of their voting rights. Could you talk a little bit about that? Okay,
yeah. So this Alabama case is actually one of many redistricting cases, and I know we're going to talk about others. That is part, again, of this movement to secure and maintain power in the legislatures. So ever since really President Obama was elected, Republicans have said, we're going to take over the legislature, because you know what the legislature does in each state? They draw maps. They do the redistricting. So very, broad lens here. Legislature makes laws. In Congress, that's like the big legislature. They make laws. Congress has the Senate and the House of Representatives. The House of Representatives, how many representatives each state gets depends on population. So every 10 years we do the census, and that requires states to redraw their voting maps because the population has changed. That is the time, and we're in that time, that post-census voting era. We just did the 2020 census, and it was fraught. President Trump demonized the census. People were like getting threatened and called racial slurs and stuff out in the countryside. People were afraid to report on the census. They're redrawing the maps. So in Alabama, they were redrawing the maps. The legislature does this. The map that they drew did not measure up to the Voting Rights Act of 1965, which says you can't discriminate in your voting procedures based on race. So they drew a map that only had like one majority Black district. The federal court in Alabama said, no, you need to have two. Mind you, this federal court had two Trump appointees. It was a 3-judge panel, 2 Trump appointees, 1 Clinton appointee.
So it was egregious. And of course, all Alabamans know that's the so-called black belt. That's Terry Sewell's district. She was the one who most recently pushed for Fred Gray to get that Presidential Medal of Freedom. But yeah, everybody knows that district. But you're saying these Republican-appointed justices said, wait, this is illegal. You got to have at least 2.
Even the Republican judges, the Trump judges said, yeah, this runs afoul of the Voting Rights Act. It discriminates. The conservatives on the other side were like, no, they cried foul. They were ordered to draw another map. They said, no, we're not going to draw this other map. Let's go to Supreme Court on the emergency docket, known as the shadow docket. And the emergency docket is typically used for, say, somebody on death row who needs clemency right before they're being executed. So this is a docket that's been around. It's when the court needs to act really quickly.
So you don't go through the court of appeals, you don't go through years, you go straight to the Supreme Court.
You go straight there. But I mean, it had a function. Most courts have this. They issue injunctions or they stop something from happening.
The so-called Muslim ban. I mean, we saw it again with the abortion. Right. Let's go appeal. Yeah.
So the conservatives have abused this. They've introduced like substantive stuff into this docket, including this case. And the court actually stopped the federal judges in Alabama from stopping that map. So that map that was clearly discriminatory was used in the primaries in May, and it'll be used in the fall. But the court in the fall will hear the full oral argument and get the full briefings on this case to determine whether that map runs afoul of the VRA. Now, all the judges in the lower court said it's clear it runs afoul of the VRA, but so why is the court even thinking about this? Well, the suspicion is they are going to gut further gut the Voting Rights Act so that it's not even a thing anymore.
But in the meantime, they gave the excuse that it was too close to the election to redraw the map. That was back in February, I believe. So they had plenty of time. And so by default, the Republicans won, and they were able to take away political power, dilute political power from Black people by packing them all in one district. They're 1/3 of the population. So it is the people of color population that is growing, but yet it's not being reflected in the redistricting maps. And the other important part of these maps we can see in Wisconsin and other places is that they're drawing these maps in such a way that the popular vote, Democrats are getting the majority of the vote. But say in one state, they may get over 50% of the vote, but the Republicans will win 10 seats and the Democrats will get 4 seats. So there is a gap between what the actual will of the people versus the political power that is being concentrated in the hands of the GOP.
Absolutely. And this is why we said last time that Kavanaugh dissent in Dobbs was disingenuous, because all that talk about the will of the people.
No, we know. Alito too. I mean, in the majority, no question. We're going to take a pause and come back. And thank you. In fact, we're going to probably have to devote a whole Black Table session to state courts, because we know the Wisconsin Supreme Court is just out here rogue, telling the governor he can't make appointments and all this kind of thing. So, absolutely, no question. So we're going to come back in a moment. We're going to continue this conversation on the other side. We kind of introduced the question of Clarence Thomas, and we want to clear up something around interracial marriage. A lot of people say, why did he leave Loving Virginia out in the conversation on the 14th Amendment? But we'll talk about that and more when we come back here at the Black Table, here on the Black Star Network.
Folks, Black Star Network is here.
Oh, no punches! I'm real revolutionary right now.
Support this man, Black Media. He makes sure that our stories are told.
Thank you for being the voice of Black America, Roland.
Stay Black. I love y'all.
All momentum we have now, we have to keep this going.
The video looks phenomenal.
See, there's a difference between Black Star Network and Black-owned media and something like CNN.
You can't be Black-owned media and be scared.
It's time to be smart.
Bring your eyeballs home.
You dig?
Welcome back to the Black Table here on the Black Star Network, our regular legal roundtable convening to continue to discuss the Supreme Court, the current term, immediate past term, and the one coming up in the fall. When we left, you were walking us through how this will of the people is filtered through this political process that the Supreme Court seems to be continuing to undermine. And as you say, the rematch, they gutted it in the Voting Rights Act in Shelby County versus Holder. And now it looks like they're going to finish the job in Murrow versus Milligan if they can. Let's talk a little bit about this upcoming term and some more of what we can anticipate for the coming term. But I guess before we do, could you clear up this question? A lot of people have been saying, well, we see Clarence Thomas in his concurrence in the abortion case previewing, well, if there's no right to privacy, there's no right to contraception, there's no right to same-sex marriage or LGBTQ protections. But they say, well, he left out Loving versus Virginia. Help us understand why that probably it's a little bit more complicated than that.
These people are sophisticated. That's one thing I keep saying. Don't underestimate these people. They may be evil, you may dislike them, but they know what they're doing. And Clarence Thomas included. He knows that Loving versus Virginia had 2 prongs: substantive due process, which he said, let's just do away with, and equal protection. He didn't say anything about equal protection. So he knows if we take away this one rationale, the decision that allows him to be married to Jenny Thomas still stands under equal protection clause of the 14th Amendment. Okay. So that's in a nutshell, that's what that's about. So he knows.
And by the way, I know before we get to the current coming up, just very quickly, either of you or both of you, like, do you think there should be some ethical rules for the Supreme Court? How come the Supreme Court is the only federal court that doesn't have any rules? Every other level, district court, courts of appeals, they've got ethical rules. You got to recuse yourself. These people just get to do what they want. Anybody have any thoughts about that type of court reform? Because Jenny Thomas out here holding whole scale
coups.
Come on, tell us, Rob.
Very deep in. Absolutely, there should be ethical standards that the court is held to. We cannot depend on the honor code, because clearly Clarence Thomas in that decision that he was the dissenting opinion that was trying to protect his wife's participation in the coup planning demonstrates the honor code is not going to work with this Supreme Court. So Congress needs to step in and impose some ethical standards on the Supreme Court. It's called checks and balances. And the court is acting with impunity largely because Congress is so dysfunctional and gridlocked that third branch of the government is not doing its part to hold the other branch, the judiciary, the Supreme Court specifically, checking its power. And so therefore, not only are they sophisticated, they're also just using raw, naked power and abusing it.
This is, y'all know it's the Black Star Network. It's not raw naked power. It's raw naked power. But naked power. Let's walk across that bridge. That's actually beautiful, Prof, the way you framed that, Professor Watkins. I was having a conversation recently with our colleague and our friend Evelyn Brooks Higginbotham, who of course is at Harvard University and was the immediate past president of the Association for the Study of African American Life and History. And we were talking about the students versus fair admission versus Harvard case. And we both agreed, in fact, we were laughing about it, that Ketanji Brown Jackson, now that she's been sworn in, should take a page from Clarence Thomas' playbook and not recuse herself. She already said she's going to recuse herself because she's got these Harvard ties. And Dr. Higginbotham was like, I really wish she wouldn't. I said, I'm with you, Prof. I mean, so talk about this upcoming docket and this SFFA case, which I got a real insight with her. In fact, maybe we'll try to schedule her and some others to talk about this. But what's coming up? The affirmative action case, Moore versus Harper, what is an independent state legislature doctrine? And maybe we can get into the Indian Child Welfare Act with the Holland case and some others. But what are you seeing in this upcoming docket that causes you concern for us?
Well, we need to talk about all three of those because they're huge. But I guess starting with affirmative action. So the SSFA, Students for Fair Admissions.
Mm-hmm. Incorporated.
Yes. They are back.
That's important.
Because it's a front organization by this man named Edward Bloom, who is president of it, who has been engineering these cases to end affirmative action. He tried in 2016 with Fisher versus University of Texas. He lost that case. He's also the person that's financing and was behind Shelby County versus Alabama. So this is very much a political, orchestrated, systematic political campaign to dismantle the civil rights gains of the 1960s and 70s.
And for those of you writing down, that's Bloom, B-L-U-M, not O-O-M. So y'all look up Ed Bloom. Oh, go ahead, Prof. Thank you, Professor Watkins. Professor Porter, you were about to.
Yeah, no, actually, that's exactly what needed to be said, because this is a long range takedown of affirmative action that includes Fisher, that includes, it actually is sort of related to Shelby County v. Holder. But in any event, in Grutter versus Bollinger in 2003, we have higher education affirmative action law sort of laid out. And the court there, Justice O'Connor, says that diversity and the benefits that flow from diversity are a compelling state interest. That's the standard you need to be able to consider race in admissions. You got to have some sort of compelling state interest. They said, hey, diversity and the benefits that flow from that are a compelling state interest. O'Connor also says that in 25 years, that's not going to be a compelling state interest anymore. 25 years, 2028. We're going to be done with this project of considering race in college admissions. By then, everything should be good. arbitrary, had no basis in reality.
That's right. That's right.
Childish notion of progress, as W.E.B. Du Bois would say.
Crazy.
Anyway,
this is the question of judicial interpretation. She just pulled a number out of the air. The air. Yes.
So back then we heard from Justice Thomas, who I know is just chomping at the bit to get rid of affirmative action, and it will happen. They are going to end this.
So what are the implications of that? Because even in talking with Prof. Higginbotham the other day, we were talking, and Harvard has all these non-white students. So I mean, is this really an issue? Who is this going to hurt?
Well, certainly we don't see the population of African Americans drop. And part of his Bloom's sinister strategy was when he lost to Fisher, who's also a part of the leadership of that Student for Fair Admission. Her and her father are on the board.
Really?
Richard Fisher and Abigail Fisher.
Abby Fisher couldn't get into the University of Texas at Austin. Went to LSU. Abby Fisher, get your weight up, get your grades up. Abby Fisher, you couldn't even get it.
He went to UT Austin too. Edward Bloom.
Oh, Bloom is a hook 'em horns. Okay.
Absolutely.
This gang. So
his strategy, I mean, he said he needed an Asian plaintiff. And this is a deliberate strategy. And it's a deliberate strategy to pit different cultural groups, racial groups against each other. But the winners, the primary beneficiary are going to be white students because it's the artificial inflation of white students. Actually affirmative action too for white males because they were falling behind and more universities were admitting white females, and the population imbalance was great, and so that they can have campus population that had white males to be there with white females, but we're seeing greater graduation rates of white female. And so it's not minorities that are deflating the Asian population's representation at these schools. It's the affirmative action for legacies, for white males, and for athletes and others who are big, and the children of faculty.
No question.
Yeah, they are a high percentage of people admitted to Harvard. So Bloom cherry-picked the statistics to support his artificial case.
And that's why we had, I mentioned that's why we had Professor Natasha Werku on to discuss her book Race at the Top for this very reason. White folk were falling behind. They just changed the damn rules. And so you're going to write, go ahead, Professor Porter, and you make this
right. And it's also a two-pronged sophisticated attack on affirmative action because this is a consolidated case. There are two cases here. There's Harvard and there's UNC Chapel Hill. Harvard's a private institution. UNC Chapel Hill is a public institution. So I won't get into the minutia there, but there's different legal analyses for public versus private universities. So Bloom said he's going to take this out in one fell swoop and get these two cases before the court so they can decide both this question of whether Grutter is constitutional or whether Grutter rather should be overturned and whether affirmative action is constitutional in both public and private universities.
And remember, race is only one factor among many factors that are considered. So it's never considered alone or exclusively.
Right, that's the rule from Grutter.
And Grutter was basically said it had to be narrowly tailored. And so, again, he is a hater.
No question. No question. You don't want your affirmative action to go away. I mean, it's been around since 1492. So we're going to come back in a moment. We're going to take a pause here. We'll probably go through a little bit of a lightning round with some of the other terms and cases that are coming. And when we return, we're also going to ask our legal roundtable, at what point does the Biden administration consider asking Congress to expand the court? I mean, at what point do we just drop the gloves, or did Joe even have any gloves to drop in the first place? Well, we'll come back in a moment at the Black Table and discuss these upcoming cases and solutions. Back in a moment.
We're all impacted by the culture, whether we know it or not. From politics to music and entertainment, it's a huge part of our lives, and we're going to talk about it every day right here on The Culture with me, Faraji Muhammad, only on the Black Star Network.
Back at the Black Table here. Welcome back. Greg Carr, Black Star Network, Angela Porter, Valethia Watkins, our legal roundtable. And as you can see, you're not going to see this anywhere else. So make sure you support the Black Star Network, because this is the kind of work that we have to do to be clear, and so we can move collectively and continue to transform the society. Professors, this Moore versus Harper case, this question of an independent state legislature, this case that the Supreme Court is going to hear in the fall. What is independent state legislature, and why should we be very concerned about this line of thinking from this court?
Well, basically, there is an article in The Atlantic that said this is the case that can blow up the American electoral process. It can introduce chaos in the electoral process. But basically, this is a fringe legal theory, a cover story to basically concentrate power into the hands of these Republican-controlled state legislatures. And in essence, they want to cut out the state Supreme Courts. They want to cut out the state constitutions that will that would allow the Republican-controlled legislature to be the sole body without review, pretty much setting rules for federal elections. And this has big implications. For example, it has implications for, we do not directly elect the president. When we vote, we're electing electors by the state. And so this could
I'm sorry. Somebody may not have had a civics class. Could you say that again?
The electoral college. The president is not elected by the popular vote. We are voting for state electors who then go and vote for the presidency. Now, many state constitutions says those electors must follow the popular vote, what the will of the people. But that does not have to be the case. And if you concentrate power in the hands of the Republican state-controlled legislature, and they alone get to decide, these partisan, hyper-partisan bodies, they're going to decide to vote in their own interest. So you're basically going to sever the ties between the popular vote and the state electors, or who's going to elect the president. And so it's going to allow these legislatures to pick the president, not the people. And so this is very radical. And this is also why we keep responding with, but what they're doing is so unpopular, it's so against the will of the people. We're just our power is supposed to be the ability to vote them out of office, to remove them if they don't reflect our interests. But with this kind of structural change, this kind of systemic rigging of the vote process, and that is them having exclusive power on deciding how to vote, who can vote, and who counts the vote, then this is basically amassing power to them with no way for the people to weigh in. And so that's why it seems like what they're doing with abortion and other things would be otherwise considered political suicide, because you're so out of step with the people. They don't see it that way, and they're pressing forward because they're rigging the system in a way to guarantee white minority rule and guarantee Republican rule for the foreseeable future. No matter what.
Two quick questions. One, this legislature, as distinct from governors, attorney generals, we saw the voting rights case in North Carolina where the governor and the attorney general thought one way, and the Supreme Court let these two members of the White Nationalist Party intervene. The Wisconsin case, with the Democratic governor in Wisconsin who wants to make these appointments, the Republican legislature will not confirm his appointments. So the Wisconsin Supreme Court tells them, yeah, you're okay. Your people you appointed that were appointed under the Republican can remain there. You know, how important is it for us to understand, even for the upcoming elections, how this theory of an independent state legislature could decide the 2024 presidential election? Because are you saying that some state constitutions say you must appoint these electors based on the popular vote, But that's not in the federal constitution. Is that what they're hanging their hand on? Go ahead, Professor.
Well, okay, so that's the next chess move. The Moore v. Harper chess move is about congressional elections.
Mm-hmm.
But the fear that Dr. Watkins raised is very real because this court is so freewheeling. But let me just really quick summarize the legal theory that's getting them there. So they're relying on the elections clause of the Constitution, which says that the time, places, and manner of holding elections for senators and representatives should be prescribed in each state by the legislature thereof. So this is how they're weaseling in through congressional district drawing. And again, it goes back to the redistricting. There's two types of what is called gerrymandering, which is drawing districts in a way that entrenches power of one party. There's the racial gerrymandering, which we talked about, which is forbidden by the Voting Rights Act. And there's partisan gerrymandering, which some state constitutions forbid. And this is how they're getting in there by saying, hey, state courts, you can't check us when we do partisan gerrymanders. The problem with partisan gerrymanders is they're also often racial gerrymanders. Right. So this impacts us because we tend to vote on party lines. But they're saying, hey, we're going to just...
You got to scream the N-word, basically, to be called a racial gerrymander. And we know they're not doing that. So, but they said...
Also, the Supreme Court in 2019, Rancho case, basically took the federal court...
Yeah, I was just about to get
partisan gerrymander. So again, you're setting up the state legislatures as the sole authority over these
exactly. I was just coming there, Dr. Watkins.
And the majority are controlled by Republicans. Over 30 state legislatures are controlled by Republicans. So
that is the chess move that came before. The Rucho case in 2019, decided by Chief Justice Roberts, 5-4 decision, where they essentially said even the federal courts, the Supreme Court and the federal courts cannot check legislatures when they do partisan gerrymandering because they say that's a political question. That's not in the province of our branch of government. So they put it back to the legislature. So this is all to consolidate that power. And it's all part of that long range plan where these state legislatures, which have become very conservative in response to the Obama presidency, essentially get to go unchecked, draw these maps that benefit them and that essentially nullify and dilute our votes so that they can retain power.
So and we're running to a close. I want to give a few minutes to what you all think can be done, whether the court should be expanded, engaged in political process. But I just want to ask very quickly, and maybe this is a yes, no answer. So you saying if the electoral map in 2024 presidential election looked the exact same as the one in 2020 in terms of red states, blue states, that these Republican controlled red states like Georgia, other places, could literally award those electoral votes to the loser of the popular vote in that state?
They will complete what Donald Trump tried to do in 2020. They absolutely can pick the next president. These are swing states too. They can, regardless of what the people say. So you can have again, and we've been seeing this over and over again, where you have the Democrats getting the popular vote, but the Electoral College opens the door for stealing the elections for foreseeable future.
At the state level, which is a crucial difference from before. Well, we know they tried to do that in Bush versus Gore, and we know that Comey Barrett, Kavanaugh, and who else was down?
Well, Coney Barrett, Amy Coney Barrett actually argued against the independent state legislature theory back then as a litigator. However, that doesn't mean anything. I mean, she can have changed her mind, and she probably has. But just to set the record straight on that.
Well, thank you. Actually, that's a very important point to be made. We only have a couple of minutes left, but let me ask both of you. We want to know, how would you fix this? Would you be for expanding the court? As Samuel Moyen and many others, there was a commission that the Biden administration convened with recommendations. Can this be fixed? And if so, how?
Well, real quick, because I'm going to defer to Dr. Watkins on this, but really quick, and as far as the independent state legislature theory goes, so if you look at that clause in the Constitution, the second part says essentially, but the Congress may at any time enact laws to alter such regulations around how elections are run, aside from choosing the place. So what needs to happen is the Congress needs to start working again. They need to get rid of that filibuster.
Well, it is working for the White Nationalist Party.
Right, right. The Congress needs to come in and basically put the kibosh on this theory. Otherwise, it's over.
Well, there is a small window, and Democrats need to act with urgency. This is not business as usual. This is not the usual election cycle. This small window is in this 2022-2024 cycle of voting, and they may already lose it in 2022 if the Republicans come to power. And so we have a simple choice. We either fight back or surrender. And I'm not for surrendering. And so we have to fight back. And Congress could do something, but Congress is dysfunctional and gridlocked. So Democrats got to get it in their mind. This is not usual. They're going to be locked out of power for the foreseeable future. This court is young. People like the Trump appointees are all very young, under 55. And so they could be there for another 30, 40, 50 years. Who wants to live with this structural built-in inequality? So yes, they need to first unpack the court. The Republicans packed the court by stealing seats. And so they use the language of packing the court to suggest that it is the Democrats trying to do something underhanded. But expanding the court is one of the best tools to do this work, to rebalance the court, to bring about a protection of people's rights, and maybe even think about term limits. People are living much longer, and so there needs to be checks and balances again. And so the court has to be put back in its rightful place as one among equals of three branches and not a super legislature, judges and legislators in robes.
And right, and this could be done by an act of Congress, huh? Simple act of Congress could do this.
Yes,
okay.
But that passive way they dealt with the Voter Rights Act, even if they had put the John Lewis Freedom to Vote Act or even fixing the Voter Rights Act, this is Roberts. Don't be fooled by Roberts. Roberts' difference in Dobbs is that Roberts believed in keeping it under radar. It was his life project to get rid of the Voter Rights Act, and he took out Section 4 and 5 and said, don't worry about Section 2, you still got that protection. And the Alabama case that Professor Porter talked about is going to gut Section 2. So he would have it on paper, the Civil Voter Rights Act exists, but in reality, it has been just blown up.
I see. And just so for folks who might not, keep track of these things, we know that the largest number of the Supreme Court, I think it was 10 under Lincoln, and there was the whole political battle with Thomas Jefferson's administration. Congress shrunk it from 6 to 5 to limit him. He got in, expanded it to 7. They shrunk it back to 7 after the Civil War. U.S. Grant moved it to its current 9 after the Greenback controversy of his administration. How many courts of appeals are there? Because I think, if memory serves me correctly, they used to be linked, the number of justices of the Supreme Court was at least loosely linked to the number of courts of appeals. How many courts of appeals are there in the country now?
Federal courts of appeals?
Yeah, federal courts of appeals, yeah.
I think it's like 90. I mean, there's
sorry, not the court. The circuit.
13? I'm not sure.
13, right?
Around 13.
No, not circuit courts. Yeah, circuit courts. I'm sorry, I said courts of appeal. I should have said courts of appeal. Right. That's right, 13, right? So the logical thing would just be to maybe have 13 justices.
13.
It is interesting, isn't it? Maybe we'll close here for now with maybe some final remarks about how we think about this government of this country we call United States of America. Judicial review, judicial supremacy, the number 9 stuck in our heads. How much of this is just myth making? How do people take the power back? The people that we know Sam Alito doesn't believe in, or Kavanaugh is just making this up. How do, quote unquote, we the people really seize back control of what is clearly being set up to be a white minority government in this country?
Well, for Black people, we have to Sankofa. We need to go back and fetch it. We need to stop being distracted by all of these mechanisms of distraction that are out here, social media, all of that. And we need to look at how our ancestors persisted in these times of trouble
Yes.
And learn from that. And we need to be active, build up our institutions, build up our organizations. And we're trying to do that here right now, but we really need to get in there and dig deep and look at the strategies that are going to help us.
Absolutely. Professor Watkins, get the last word.
Well, we have to get involved. We have to be engaged. We have to organize. Join an organization that's fighting in some kind of way. Do not become despondent and depressed. I think about the old gospel song, I don't feel no ways tired. Come this far from where I started from. Nobody told us that the road would be easy. I don't believe he brought me this far to lead me. I don't believe our ancestors have brought us this far. I don't believe God has brought us this far to leave us. And so we can't leave them. And we have to think about the children when we get tired. That's what Fannie Lou Hamer said. She said, I'm sick and tired of being sick and tired, but she didn't sit down and look at her neighbor. She got up and did what she could. And she always said that she thought about the children, the next generation. That was us. And now it's our turn to return the favor for those who's coming behind us.
That's a good place to pause, Professor Watkins, with the words of Fannie Lou Hamer. Thank you, Professor Valethia Watkins, Howard University, Professor Angela Porter, American University, and our regular legal roundtable. Something tells me we'll be asking you all to convene again fairly soon. Thank you so much for joining us. And we'll be back in a moment to clear the table.
Hi, I'm Dr. Jackie Hood Martin, and I have a question for you. Ever feel as if your life is teetering and the weight and pressure of the world is consistently on your shoulders? Well, let me tell you, living a balanced life isn't easy. Join me each Tuesday on Black Star Network for A Balanced Life with Dr. Jackie. We'll laugh together, cry together, pull ourselves together, and cheer each other on. So join me for new shows each Tuesday on Black Star Network, A Balanced Life with Dr. Jackie.
Welcome back to the Black Table here on the Black Star Network. I'm your host, Greg Carr. We were joined today by our regular legal roundtable, and Professors Porter and Watkins helped us and reminded us that we must be engaged and involved. There were a number of cases we didn't talk about coming up on the Supreme Court docket, and one of them is another administrative law case talking about whether or not the federal government can regulate businesses, regulate states. We know that in this current term that was just ended, that one of the major cases decided was a case dealing with the Environmental Protection Agency and their ability to reduce carbon output at existing power plants and regulate that. And the Supreme Court said, no, you don't have that capacity to do it. And so what we see is the children's lives, our lives, but certainly our children's lives and the future's lives are really at stake. So we have to ask ourselves some fundamental questions. Who are we the people? And when is that dispositive? Under what circumstances are we the people dispositive in how we live and how we are governed? Well, who has the final word on liberties? Who has the final word on protections of rights? Who has the final word on rights? Who has the final word on guarantees of life? Of the capacity to live to our fullest abilities, not just in the United States, but in the world. We have to take those questions very seriously now, because there are a few people who think that they should make the decisions for all of us, and that simply will not stand. Join us next week here at the Black Table on the Black Star Network. Don't forget to support the Black Star Network, spread the word. You see, we're building something special here. You're not going to see it anywhere else. So we are grateful that you join us, and join us again next week. And in between time, join us on all of our other programs on the network. So see you soon.